to no more than an hour, please, Larry.
Yeah, I actually have a 1:30 call about our complaint against the president, so I will definitely be over by then.
Okay, that's brilliant. Thanks, Larry.
Let me see how I can get this back to, okay. Are we ready?
Yeah.
Okay, all right. Well, welcome everybody, and thank you for the opportunity to speak to our brothers over at across the pond. I'm thrilled to be able to meet you people. Haven't, except for a handful, I haven't been, I've been reading a lot that the Dealey Plaza UK puts up on their website, but I haven't had a chance to meet most of you. So I'm glad to have this opportunity. What I'm going to talk about today is a couple of things. First, I'm going to give you a little history about how we got to the point where these records were classified in the first place. As you'll see, the Warren Commission materials were improperly classified, never should have been classified. And then we're going to talk about some of the initiatives that a group of lawyers that I've organized have been doing. And today is actually an important day for the JFK Records Act, because pursuant to President Biden's October 2021 executive memo that had postponed the release of the records till December of this year, December 15th, today is the day when agencies that want to further postpone records past the December 15th deadline, if they haven't been able to work out a deal with the National Archives, today's the day that they have to either withdraw those postponement requests or go to the president and ask him to overrule the NARA objections. And NARA also, the National Archives, today is the day they have to contact the president and notify him if there are documents that they agree can be postponed again. And we'll go into that as we get going further on. I'm going to skip some of the slides or go over them quickly. They'll be available for you to review in detail. But we start off with, this is President Kennedy's statement about, to not withhold documents more than 15 years. Obviously, the records about his assassination have violated the president's own instructions. So just wanted to point that out to you. And the Warren Commission records, initially from January to April of '64, the general counsel for the Warren Commission, Rankin, instructed the court reporters that any testimony before the Warren Commission was to be marked top secret, which is the lowest level of secrecy. But he did that, and you'll see in a minute that that was not, he had no authority to do that. And then in May, he also asked the court reporter to mark as confidential all the transcripts of the executive meetings. Depositions and testimony were to be marked confidential, but the transcripts of executive meetings were to be top secret. Now, I'm sure everyone, when they think about executive meetings, they think about the meeting in January, I think 27th, when the commissioners met in executive session and talked about this rumor about Oswald being an informant for the FBI. So all these transcripts were originally classified, and it wasn't until many years later that they were released. This is the letter from Lyndon Johnson to the archives, instructing that they don't have to comply with the particular, there's an executive order that had been in effect. And this was that when you had a document that was declassified, it was supposed to be a stamp on it. Does that sound familiar? So this was just a letter from the president advising that this requirement was not met. And then what happened? There was a article published in the Washington Post in December of '64 where I believe someone in the National Archives had mentioned the records were going to be kept for 75 years. They wouldn't be disclosed for 75 years. That was pursuant to existing policy for classified records at that time. The theory in those days was that people 75 years would assure that whoever was the subject of that information would not be alive anymore. Anyway, this mayor from Cedar Rapids, Iowa, wrote the president complaining about this cloak of secrecy for 75 years. And that started, that created a kerfuffle, and that started a process within the White House. So what we have here, you see that this is the chronology. The records in November 64 are transferred to NARA with no guidance or no restrictions on the materials as to whether they could be released. LBJ issues his memo in November 23rd, and then the mayor writes his letter on January 5th. It gets the attention of the White House. McGeorge Bundy then writes a letter to the acting attorney general, Katzenbach, in January, asking the DOJ to basically consult and determine, if there are any exceptions that may be established. And I remember this is all before the Freedom of Information Act has been established. In April '65, Department of Justice issues guidelines for the public availability of materials delivered to the National Archives. LBJ then shortly orders that the Department of Justice to implement these guidelines, and then the Department of Justice begins doing its review in '65. Meanwhile, there's a law passed that basically says all the information and records that were evidence that was obtained by the government is to be considered property of the government. This was directly in response to Marina Oswald's attempt to sell the alleged assassination rifle. In response to the Department of Justice doing this review, in July of 1966, the archivist sends a note to the Department of Justice letting him know what's the status, and he says that 80% of unpublished executive branch material are now available to the public. But there's a large quantity of material, such as testimony, minutes, memos, correspondence, affidavits, investigations, that have not been released. And the bulk of these remaining materials are classified, and there are other materials that are not disclosed because they could prejudice the Ruby trial. Interesting. In addition, FBI had its own 1,000 exhibits that were waiting to be transferred. And the archivist, this is, I think I'm not sure if FOIA was passed yet, but they were going to be subject to 5-year reviews. So every 5 years, the documents would be reviewed for declassification. Then there was some more conversations. There were certain questions about what documents fell within this category of being able to be released. And interestingly, there is the NARA made some tentative determinations as to what documents could be released based on the Department of Justice guidelines. They also mentioned on August 17th of '66 that they can't locate the autopsy photos and x-rays. September of '66, DOJ basically confirms with the NARA that their interpretation is correct about what materials can be withheld and what can be released. Then we have the autopsy materials are found, and then they're deeded over to the at that point it was General Services Administration, which where NARA was located. Actually, then it was called the National Archives Records Service. And Attorney General Ramsey then issues his order after all this back and forth, indicating in connection with that statute that was passed that anything that the body of evidence that's in possession of the government is to be preserved intact, and any evidence that's not owned by the government, they should try to pursue and get it. So we have some more back and forth between the archivist and the Department of Justice. We had the deed of gift in '66 for the autopsy materials, and in 1968, there is a determination that the autopsy materials can be reviewed by the public pursuant to the deed of gift requirements, but they have to wait 5 years. So 5 years from the date they were donated, so that would be 1971. Now, in 1972, President Nixon issued a new executive order. We're going to be talking about those in a second. The executive orders govern how the classified materials are to be declassified or remain classified. And the National Archives now begins doing its mandatory 5-year review for the records. And we start beginning having a couple of interesting congressional hearings, which we're going to talk about in a minute, about secrecy, the Freedom of Information Act, and the Warren Commission records and the Kennedy records. The first one, these are little known hearings. You know, most people know about the House Select Assassinations Committee and the ARB, but there were some interesting hearings, very significant hearings held in the early 70s that dealt directly with the assassination records. LBJ, when he dies, his estate provides that his materials would be turned over to the LBJ library, but they wouldn't be released for 50 years. And then in April of 74, Harold Weisberg has a lawsuit against the Government Services, General Services Administration about getting some materials under the Freedom of Information Act. And the counsel for the Warren Commission claims that he had the authority to classify information. So then we have the two hearings in 75 that are pretty important. One is the circumstances surrounding the destruction of Lee Harvey Oswald note. That was before a House committee. And then the December 9th, 1975, what I call the Bella Abzug committee hearing. There's specific questions about whether the Warren Commission had authority to classify records under the executive order. So the archivist testifies at this November 11th hearing, and this hearing, the testimony is available online. The archivist says 90% of the materials have been made available to the public. He also mentions there's a 158-page inventory of Warren Commission records, and that he explains that every 5 year, well, there's a 5-year review, and then there's a 10-year review after that on declassification. And he was explaining just how this is the general rule and how they're giving an update on what they're doing, and how really the rules are kind of set up because of the constraints that the NARA has on its resources. There's actually some really interesting stuff about what records they were reviewing. They were focusing on the Civil War and stuff, but if you want to read it, that's interesting. But David Bellin has the most interesting testimony. And remember, David Bellin was an attorney for the Warren Commission, and he was the general counsel for the Rockefeller Commission. And he acknowledged in his testimony that there was an overclassification problem. He mentioned, in fact, that the staff kind of laughed at this fact that these are marked as top secret because the staff had not been cleared for reviewing classified materials. And he said the public's right to know, far overrides any considerations of what might be considered breaches of national security. And he felt that the public's right to know about the murder of the president should prevail over the natural inclinations of the Kennedy family about the autopsy photographs. He also mentioned that the autopsy photographs and x-rays were never introduced into evidence, and that was a way to avoid these being made part of the public record. He also talks about the single bullet theory, very interesting. He says that when he was asked about the reconstruction of the shooting, and he said, what we did not do, and what I believe we should have done, was when we had the marksman tests run, we should have run them with the moving vehicle rather than with a stationary target. He says the argument against reproducing the exact shots was that we did not have to show that it was necessarily probable. All we had to show that was reasonable, probable to do what was done, and that is the way the tests were run. So the tests were really just designed to see if a bullet, if there was enough time to fire the shots in the time period. They didn't really test or do any ground truthing on whether the single bullet theory actually was plausible or actually reasonable. They never, tested whether what would happen if a bullet went through two people. And so that was kind of interesting testimony there. The Freedom of Information Act was passed in 1966. I believe it became effective at the beginning of 67. But this has been the grounds that have been used oftentimes to prevent release of records. And the first exception is records that are required by an executive order to be kept secret in the interest of national defense or foreign policy. And that's been the #1 grounds for denying access to any Kennedy records. And the other one, the most commonly used, was the 7th exception for investigation files. And the FBI has relied on this heavily. In fact, they relied on it so heavily. And obviously, in the 70s, when they were asserting this, and they continue to assert this today, there is no current investigation going on in the Kennedy assassination. And yet they were using this exception. And in 1974, Senator Ted Kennedy actually led an effort to amend the FOIA Act to rein in this discretion under this category. And as you surprisingly may not be surprised, but Freedom of Information Act does not comply or does not apply to Congress. Instead, Congress has its own rules. So the House rules have provided that records less than 30 years are unavailable, and for more than 30 years, you have to get written permission from the clerk of the House, and that's what the ARB did. The ARB had to go, the Assassinations Records Review Board had to go to Congress and get permission to review and inspect the House Select Assassinations Committee records that were not records that had been, if the FBI or the CIA gave records to the committee, those agencies retain ownership of those materials and they are subject to the Freedom of Information Act. But if it's memos or transcripts or stuff or correspondence, stuff that's generated by the committee, those records are only permitted to be released upon permission from the clerk. And as you know, we still have outstanding church committee records that are missing. So these are some of the executive orders. I don't want to go in, you can read this at your leisure. I just note that President Eisenhower's executive order in 1953, which was in effect, except for a slight modification by President Kennedy, was that if the agency or unit was not named in executive order, it does not have original classification authority. And that's what happened when President Johnson created the Warren Commission. He did not specifically give them the authority under the executive order to classify materials. And I'll show you the difference in the order that was created for the Rockefeller Commission to show you how that's different. President Nixon's executive order in 1972 actually opened things up. So he moved the declassification to 10 years with certain exceptions, which, and remember, we were talking about 75 years before then. He also said classified information, which is more than 30 years, shall be classified unless the head of the agency, of the originating agency, determines in writing that they have to be protected, that the continued protection is essential to national security, or that disclosure would put a person in immediate jeopardy. And there were some interpretations of this Nixon order. President Carter went a step further and said that the government had to balance the public interest and access to the information. So there was a balancing test that was put in also, that if there is an identifiable harm and the agency wants to withhold the records, they still have to, under the Nixon order, you ended that. But now Carter added an extra provision and said you have to then balance that desire or that harm against the public interest. Reagan came in and completely eliminated the balancing test. He also gave agencies the ability to reclassify documents after receiving a FOIA request, and he removed any time limit on classification. And then President Clinton came in, and he, again, as you might expect, loosened up the rules. If there was significant doubt if the information was to be classified, It was to be declassified. He reduced the classification period down to 10 years from the 30 years, and also required automatic declassification when the record was over 25 years with some limitations, and required agencies to come up with a systematic declassification program as opposed to doing it ad hoc. And also the National Archives was required to make a government-wide declassification. President Bush pulled back a little bit, added more exceptions to the automatic declassification. And that's where we were when the Kennedy Act was passed in 1992. And you'll notice, I don't know if any of you have read the act with any kind of legal viewpoint, but there's, in the findings section, you'll notice there's a presumption of immediate disclosure. The legislation was passed because we needed an enforceable and independent and accountable process. The legislation was necessary because the way that the executive branch had been administrating the Freedom of Information Act and also the national security orders, they have been preventing the timely public release of records. And that's the section here that and then Congress is saying 30 years is enough. Only the rarest cases is there a legitimate need for continued protection. Well, now it's 30 years since the act. So the amount of time that has passed is the equal amount of time since the assassination when the law was passed, and we're still having at least 15,000 records that are in full withholding. And here's a section for periodic review. So records are supposed to, that are withheld, are supposed to undergo periodic review. 5GD is the section that's in dispute. It says that each record shall be publicly disclosed no later than 25 years, unless the president certifies, and this is what Donald Trump and President Biden did. They certified that continued postponement was necessary, and that the identifiable harm outweighed the public disclosure. But this is supposed to be record by record, as opposed to just making a sweeping assertion. And you'll see the grounds for postponement. So this is the criteria that the government or the president is supposed to use. So they have to use clear and convincing evidence, which is like a criminal law standard. And here, and you have the threat to military. So this is the military or national defense, persons that would be, that were confidential informants. They're revealing their identity would cause them substantial risk. And these are more grounds. You can look at them at your leisure. And there were some important rules of construction. How are courts to interpret this law? And this law takes precedent over any other law and common law, except for records that are subject to protection under the IRS code. The Freedom of Information Act should not be used to eliminate or limit any rights to information. And nothing in this judicial review, there's nothing in this law that would preclude judicial review under the Administrative Procedures Act. So basically, this act is taking supremacy over any other laws except for the tax law. In fact, after the ARB went out of business, the CIA issued a memo called Lessons Learned. And that memo discussed the differences between the Freedom of Information Act and the JFK Records Act. And that memo, which is written by legal counsel to the CIA, said that the common grounds used in the Freedom of Information Act for withholding records, which is in addition to the national security and the information, investigation files for law enforcement, was the deliberative process exemption. In other words, when people are exchanging memos and emails to reach a decision under the Freedom of Information Act, those drafts of documents or those correspondence are not disclosable. And also attorney-client privilege. And the CIA said that the JFK Act, those privileges don't apply to the JFK Act, which was a really important piece of information. It shows you how the JFK Act is much stronger than the Freedom of Information Act. So we were supposed to get the records released in 2017 pursuant to the statute, and President Trump issued 2 postponements. The first one was in October of 2017, and he identifies Section 5G2D, but doesn't cite any of the Section 6 criteria for postponement. Instead of making the record by record determination as required by the statute, he just made a sweeping assertion that the records that are to be released, release of them would pose identifiable harm, but he doesn't make the document by document explanation as to why each document, what the identifiable harm in each document is. And then B, doesn't do the balancing test that that showing how the identifiable harm outweighs the public interest. He just makes this sweep-in agreement. And the way they got to this was, I filed a lawsuit against the National Archives last year after President Biden postponed the records, seeking the underlying memos and correspondence that were involved in the Trump and Biden postponements. The government immediately settled my lawsuit at our first conference, court conference. And they've been giving me about 250 pages a month since then, since like spring of this year. And what I can glean from the memos that have been shared with me is that the National Archives actually objected to the grounds that the FBI and the CIA were using to postpone the records. And like a good team player, once the decision was made in September of 2017 to postpone the records, the National Archives was then asked to send a memo to the president requesting that the records be postponed, and notwithstanding their prior determination that the requests were not consistent with the law, they said that this postponement was consistent with the law. And that happened both for 2017 and 2018. So this is the actual executive memorandum as it was published in the Federal Register. And this is the letter now in March of 2018. So there was a 6-month postponement. And then in so that was going to be, the records were supposed to be released on April 26th of 2018. And in March 26th of 2018, again, there's this memo written by the archivist to the president, basically saying that they've reviewed it, they've sampled, and they have decided that there'll be a 3.5-year postponement, and that these are consistent with the act. Again, inconsistent with their initial determination. And this memo, there was 11 prior drafts before this memo was issued. So like anything else, it looks like it was, it looks to me like the White House did the first draft and it went back and forth. It looks to me some of this stuff was redacted, but it looks like they wanted a longer period of time. In fact, the Department of Defense wanted 10 years. The FBI wanted 5 years. So it looks like NARA was able to push back and get 3.5 years. There's actually a memo that says from the head of the NARA to the archivist saying that the president's going to have to own these dates. So you can get, there was not, they were not happy with this postponement. And you can see the people that are copied on this letter: General Kelly, who was the chief of staff for the president; Donald McGahn, who was the counsel to the president; and then McMaster, who is the National Security Assistant Advisor to the President for National Security Affairs. So this went pretty high up. And then this is the memo that the president issued. And again, he's basing his postponement that he had no choice but to accept the recommendation by the archivist. So that's how they set it up, that the archivist was going to make the request. I think it was in, let me see, was it here? Where does he say? I agree with the archivist's recommendation that are necessary. There's such gravity that the public interest. So he makes the overall statement, but doesn't make the document by document analysis. He just makes another grand sweeping statement. And then he's just quoting the statute and saying that only the rarest in cases, a legitimate need, postponed until October 26, 2021. And so what we did in 2021 was I wrote a letter to Carolyn Maloney, who's the chair of the oversight committee at the House, who retains oversight authority over the act. Asked her to engage in oversight, didn't do anything that year. We then contacted the Public Interest Declassification Board, which is an obscure Washington, D.C. agency. They make recommendations to the president on declassification. He sent a letter, the board sent a letter to the president. I then cobbled together a bunch of signatories of historians, lawyers, researchers, open government groups. We wrote a letter to the president, basically asking him to release the records and giving him a legal memo as to why the Trump memo did not comply with the law, hoping that might preempt any machinations by the White House to try to postpone again. And this is the signature by the chair. And then a bunch of Congress people also wrote a letter to the president. Steve Cohen is a representative from Tennessee, and he's actually the guy that really organizes these people. He sent several letters to the president. But then, unfortunately, President Biden issued his October 22nd memo. And it was, again, he followed the same script that President Trump did, but then went beyond the statute and says that they is critical to the United States government to maximize transparency, disclosing all information except for the strongest possible reasons counsel otherwise. That was not a standard under the act. So he created a new standard. He relies on the pandemic as saying that why we need additional time. Of course, they had 3.5 years since 2017, since the 2018 postponement, on top of 25 years before then, but somehow the pandemic was the grounds for postponing for a year, and he doesn't want the archivist to make decisions in haste. So he issued another temporary certification for 1 year. And instead of having it done in November, they're pushing it back to December of 2021 out of respect for the president's memory. National Archives is actually excited about this memo because it required them to do a digital review. But that's bureaucratic gobbledygook. Let's see, the agencies were required to do an intensive 1 year review. And he's claiming they should not be limited to the absolute minimum under the statutory standard. He uses other phraseology, a substantial weight to the public interest. That's not what the standard is. Some degree he gives an explanation. He's trying to look good, for when he postponed this. Now, there's the one interesting thing is an unclassified letters to be sent by the head of the agency. I don't know if they're going to presume they're going to do this for document by document. And he uses terms of anticipated harm. Again, that's not a term in the statute. It's identifiable harm. In other words, harm that exists, not harm that may occur. And you can look at the rest of this in your leisure. So what's next? We have the lawsuit against the National Archives, which I'm getting memos each month, and that's actually helpful because the lawyers that I've organized is we're about to file a lawsuit against the president and the National Archives for failure to comply with the act in connection with the 2021 postponement. We've been trying to launch a grassroots effort to get Congress to hold oversight hearings. I did I sent another letter to Carolyn Maloney in September, actually in August. No, it was in July, right before her primary. And this time I had just beyond me, I had a whole bunch of historians and researchers and lawyers. And this time she responded. I'm her constituent, and she was in a primary. And I also contacted her her opponent. So that kind of, I guess, got her attention. And I've been in weekly conversations with the Oversight Committee, and they have been, for example, I gave them all the information that was generated from my lawsuit, and I gave her all the correspondence from last year. And the incoming archivist who was nominated by the president had their confirmation hearing 2 weeks ago. And so the Oversight Committee gave my material to the Senate Homeland Committee that has the responsibility for confirming archivists. And when I told them about this October 1st deadline, they're reaching out to the White House this week as well. So they don't have time to do a hearing. The congressional calendar is very, very full up this year. Plus there's an election, so they don't have a lot of time, not going to be in session much longer. But they're doing these other tools of oversight. This is my lawsuit that was filed in against the National Archives. Here's an example of some of the grounds that the agencies were using. So this is the letter in August of 21st, 2017, in anticipation of the October 26th deadline. A letter like this was sent to each of the agencies that had withheld records. And let's see, this is a letter sent to the FBI. This is a letter, wait a second, let me just double check here. Yeah, so this is after some conversations, and here, this is where the National Archives is indicating they don't agree. So justification for each of these FBI files relies on broad statements concerning possible stigmatization, harassment, and even violent retribution. Most of the records, they have like 6,000 records involving the mafia that are still withheld, which kind of confirms my theory about who killed the president. But information concerning events 50 years ago is difficult to imagine circumstances in which the individual could be harmed by the release. The standard is a high one. There has to be clear and convincing evidence, substantial risk. And so they're basically, the National Archives here is saying that they don't agree with the, it says, granting the FBI's position that it cannot unilaterally release other government information, however narrow, could support the FBI's appeal if the FBI seeks the views of the foreign government on issues. Where was it? Somewhere in here that they said that, oh, the lighter yellow. Because we can find no indication the FBI made any attempt to determine if the additional information could be released, NARA cannot support the continued postponement of the records absent additional work by FBI. So you notice that of the 7,469 documents that the FBI had appealed to be withheld, 6,097 were organized crime records. And then here is some of the 2018 correspondence. So this is, again, there's the April 26, 2018 deadline. National Archives sends letters to the agencies asking again for what records they're going to postpone. And you can see they're citing the president's statement that only the rarest cases. Here's emails between Martha Murphy and someone at the FBI. Is it the FBI? No, this is the FBI. And they're talking about how there are records that are supposedly were given to the FBI claims they gave the records to the National Archives, but in fact, they just gave the cover sheets. So it's a mess. And then this is the letter from the Secretary of Defense asking for a 10-year postponement, bottom of the page. You can see, watch this, read this in more detail. Here's the memo I mentioned to you that about the president has to own these new dates. So this is actually, you see this says version 13. So this memo from the archivist to the president, we only see version 13. The other 12 documents were drafts that were withheld under the Freedom of Information Act. We're going to argue these are assassination records because they're about assassination records and they should be released. And here is Department of Justice, March 9th, saying we're withholding records. And this is the FBI, and they're using a 100-year rule. So basically, they're saying we searched, we couldn't determine these people were alive, and we're using a 100-year rule, meaning that they were born more than 100 years ago, the individuals presumed dead, and they can release the records. The archive said, hey, you know, we can tell from a Google search that these people are still alive, but they claim they couldn't make that determination. So those are some of the records that are being generated. As I said, we're about to file, we're probably going to file a lawsuit in the next week or so. I'm actually working on the finalization of the complaint. And Neil, it's 1:15 almost. So I kept it under an hour. I know I went fast. I don't know if anyone has any questions, but I can stay for 10 more minutes if anyone has questions. Or I'm sure you guys are tired from a whole day of presentations. But this is this was a kind of a legal look at what's going on. We have a very motivated group of lawyers doing this pro bono. We found a plaintiff and we're going to pursue this. I don't know why it wasn't done after Trump delayed the records, but we are not going to let this happen again. With that, I will stop sharing. I can't hear anything, Neil. Not hearing anything.
How's that?
Can you hear me?
Oh, yeah, yes, now I can hear you, yes.
Okay.
Can you hear me, Larry?
Yes.
Okay, good. Thank you for the presentation. I just got a quick question. What's the score with the so-called digitization of the actual records that were released in the 90s? We spoke about this before, and that Biden has said that he wanted everything digitized and such. Is there any progress on that?
There's an echo. It's hard for me to hear what you're saying.
Okay, hold on.
In one of our previous conversations, can you hear me now?
Yes, yes,
Okay.
clearly, yes.
Okay. In one of our previous conversations during the Project JFK, you mentioned that Biden was, well, hell-bent is maybe a wrong expression, but he was interested in basically getting the records digitized. And I'm specifically aiming at the records that were released in the 90s and haven't been digitized, and they're not available as such. Do you know anything about any progress on that?
Well, so the government is transitioning to digital. Beginning January 1st, every record that is going to National Archives is going to have to be in electronic format. And so the government is switching over to that. NARA came up with a plan to digitize the JFK records. I don't know where they are. I mean, I know they submitted the plan. I don't know where they are in terms of implementing that. As part of the lawsuit, we have really reviewed, the collection is a mess. Part of the lawsuit is going to be getting NARA to, I mean, you know, they can't even tell us how many pages are withheld in full. There are missing documents, the spreadsheet of, there's 6 Excel spreadsheets that only represent a portion of the collection. There's no searchable tool anymore. So the collection is a mess. It really is. I think it's a function of lack of resources. We're hoping that this digitalization project, I guess we'll find out on December 15th where they are. But they were supposed to come up with a plan, which they did. I don't know if it's been approved yet.
Thank you.
I don't think you heard me. I think we were on mute of some sort. And the plaintiff is Mary Farrell Foundation, isn't it?
I can't acknowledge who the plaintiff is yet.
Okay, so you did hear me. Okay.
Yeah.
Are there any other questions from the floor? Yeah. Oh, hello. Malcolm Blunt has got a question.
Oh, okay.
Malcolm's gonna come down.
Okay.
He's hobbling down to the lectern.
Well, he should take his time.
We're all hobbling down.
I'm hoping that I can answer Malcolm's question.
Pleased to meet you, Larry.
Yes,
you.
Malcolm, I've listened to you and, you know, many years. I'm very impressed with the work you've done. You're a real legend in the field.
Yeah, I'm not sure about that. Larry, when I was at National Archives for, off and on for many years. And one of my ongoing problems with National Archives was NARA working papers. Do you know if there's any development on that? Because they seem to be withholding a large amount of documents under that term, National Archives working papers. Although they did internal reviews to release some, they did a 1985 review, and I think they did a 1993 review, but it was a lot of material, awful lot of material, and I couldn't get any index from them whatsoever. And then when I pressed them on what exactly NARA working papers were, they cited FOIA.
Yes.
That they could withhold what they liked under working papers. In other words, it seemed to me like a hidey hole. If they wanted to, pull something back, then they could do it. And there was no index. They wouldn't give an index.
Well, that's interesting, Malcolm. I was not aware of that. And when we go to file a motion about the redactions, I will add a count for NARA working papers, because again, the theory is that if there are memos about assassination records, they themselves should be assassination records, and then the deliberative process exemption under the Freedom of Information Act should not apply.
So under US Code 552, they can't do that, you don't think?
Yeah, well, if there's a final memo, they would probably be required to release that. But if there are interim memos leading to a decision, those are not disclosable. The theory is that if people knew that their suggestions and comments were going to be disclosable to the public, they would not be as candid with their advice or suggestions.
Right.
So that is the theory. But the JFK Records Act is stronger than the Freedom of Information Act. So I was not aware that was a problem. I'm going to add that to the count.
Good.
So I appreciate because that actually is important to see, how they came up with decisions. And they are the successor agency, by the way, to the ARB. They admitted that, and they don't have the same power as the ARB, but they have the same obligations as the ARB. So we're going to, part of the complaint is going to be against NARA also, not just the president.
There's a couple of other things. That was a big hamburger to digest. Good stuff. The second thing for me was difficulty in the last, from 5 years ago now, because of the COVID business.
Right.
Was HSCA records, which were over redacted. What I'm talking about is a particular set of documents which are important for researchers when they're actually trying to find stuff. And that's the House Select Committee on Assassinations incoming and outgoing document register, which holds everything. That register, Larry, is very heavily redacted. In other words, we can't see the people, some of the individuals that were testifying, some of the individuals that were writing in, the subject matters. It's just, I was just dumbfounded that so much stuff in an alleged index, which is supposed to be a release. There's 3 boxes. Well, I think it's either 2 or 3 gray file boxes of material, and it's a lot of material.
Can you when you get a chance, can you, or maybe give it to Neil, but can you send me what the RIF is? I assume it has a RIF number to it?
No, that's just part of the, there's no RIF number on it. It's just a box, just boxes in the House Select Committee records. So, well, you know the records, 300, went from 302 numbered files to 320 numbered files, you know, all that stuff. But there's a separate list, which is tagged onto that list. And that's in that second list is the incoming and outgoing document register. And that's just what you asked for.
Okay, document register. Okay, I'll take a look to see. Because again, you know, the way the ARB got permission from the clerk to release those records, but I think because Congress records are not subject to FOIA, we'd have to get permission from Congress. But that's something for me to follow up with the Oversight Committee, because they're the committee from Congress.
There's a third thing, which is like, when Alfred Goldberg, the DOD historian, was interviewed by the review board, he mentioned NSA, a lot of NSA material coming into the Warren Commission. Well, none of that stuff has been released, none of it. And he specifically talks about intercept material. Okay, that might still be classified and classified again and again. I don't know, but it's something that should be brought up, I think. He said it was the most important factor for the Warren Commission was the NSA intercept material. But now I've been through those files, Larry, backwards and forwards, and there are 440 boxes, and they're not in there.
What, the 440 boxes are the Warren Commission?
Yeah.
Okay. Now, I know the ARB in its final report discussed the NSA, but you're saying after the ARB, there's still these files that are withheld.
Yeah, that's right. I mean, there are a few NSA documents.
Okay. Well, I do have spreadsheets that, you know, each time the government produces documents, there's always a spreadsheet, and I have spreadsheets allegedly by department. I do have an NSA spreadsheet, so I will take a look at it. In fact, I'll give it to Neil, and you can take a look at it. He'll share it with you. You can tell me if, you know, if that looks like, you know, what the records they were talking about. Because it's a spreadsheet that talks about, it gives a title of the document and essentially, you know, what it's about.
Okay, great.
Oh, this is very helpful. Great. I mean, this is why people like you are so important. We're just lawyers. We're like, the biggest part of the complaint is getting all the facts about the status of what's not been produced, or what's missing, or what's all confused. We have the legal theories. We just got to get all the facts right.
Yeah, we may talk about that tomorrow morning.
Yeah.
Okay. All right.
Thanks, Malcolm. Anybody else got any questions before we go?
Can you send us this PowerPoint?
Yeah, well, that's what I was. Yeah. So you said that we could look at this stuff at our leisure. You've already sent me the PowerPoint. You're happy for me to release that to everybody?
Yes. Share it. You know, whoever wants it.
And you want it in? Should we do it in PDF form? Should we?
You could, if you can, go ahead.
To protect.
And then if anyone has any questions about what's in there, just have them email me, and I'll answer them. Because again, there may be some things, and I could send you the Bella Abzug testimony, the transcript of the testimony. People want to read it. It's actually interesting, and it's one of these things that it happened in '75, but because of the Rockefeller. Oh, I forgot to show you what happened to my Rockefeller name. The Rockefeller Commission was given specific authority to classify information. In fact, the general counsel and the executive director of the Rockefeller Commission were given the authority to classify records. So that was different from the Warren Commission. But because of the Rockefeller Commission, the Church Committee, and then the HSCA, this Bella Abzug hearing kind of got lost to history. But it's out there, and it's actually some really interesting stuff if you read the testimony.
Okay, well, look, you've got about 5 minutes before your next call. On behalf of DPUK, thank you very much, particularly at short notice, given that Nancy had to drop out for personal reasons.
I hope the crowd, the attendees found this interesting, and it's a different, kind of a little different thing of what you're used to, but it's illegal. That's what I focus on. I'm not as much a researcher as you guys are. I'm focusing on getting this stuff released, and I've done a couple mock trials. We're trying to get we're trying our legal ability to move this case along.
Yeah. Did you have?
Yeah. Larry, would you mind doing me a favor? I just want to see whether I can get the sound sorted out here. So I'm just going to try something. We're going to switch just that.
No, I can't hear you. Neil, I got to run. So okay, bye.